Presentation of dialogue on Idaho Public Television is made possible through the generous support of the Laura Moore Cunningham Foundation, committed to fulfilling the Moore family's legacy of building the great state of Idaho.
Coming up, many see it as a way to solve some of the world's most pressing problems. Others view it as a threat. What's the role of international law in our lives? I talk with Judge Joan Donoghue of the World Court next on Dialogue. Stay tuned. Hello and welcome to Dialogue. I'm Marcia Franklin. After World War II, the United States was a big supporter of international law in the hopes it would prevent another global crisis. Specifically, the U.S. backed the International Court of Justice, also known as the World Court. The court's 15 judges sit in The Hague, Netherlands, and hear disputes between countries. But in 1984, the court ruled that the United States had violated international law by supporting the Contras, a rebel group in Nicaragua. The United States then declared that the court had no jurisdiction in the matter. Today, our country only recognizes the court's jurisdiction on a case-by-case basis. But there is an American judge on the World Court, and she joins me today. Judge Joan Donoghue was elected by the members of the United Nations to her position in 2010. She was only the third female judge in the court's history at the time of her election, the second having been seated just a few months prior. Before assuming her position, Judge Donoghue had a distinguished career in the State Department and is the recipient of the highest award given by the Secretary of State. She served in many capacities in the agency, including Principal Deputy Legal Advisor, Assistant Legal Advisor for Economic and Business Affairs, and Assistant Legal Advisor for Oceans, Environment, and Science. Judge Donoghue has also served as Deputy General Counsel for the U.S. Department of the Treasury. She's in Boise and Moscow to give speeches at the University of Idaho School of Law, and welcome to you.
Well, thank you, Marcia. It's a pleasure to be here.
Before we begin and talk about the court and international law, I just want to ask you a little bit more about yourself. As I mentioned, you have had a long career in the State Department, working on all manner of issues, and I believe you studied Russian in college. Have you always had this interest in other countries and in the world?
I think I probably did. When I was in law school at Berkeley, I took any course that had the word international in it, and that really did attract me and motivated me to study more and learn more about it.
What is it that fascinates you, and why have you devoted so much of your life to intercountry issues and global issues?
Well, I think what I like about it the most is I think of international law as a profession that is in many respects quite technical and detailed, as any legal profession is, but that allows lawyers to contribute to solving problems with the kind of tools and the kinds of skills that we bring to the table that maybe aren't as familiar to non-lawyers.
And would it be also with the import of helping prevent crises and wars, using the law to solve what are sometimes very tense situations?
Yes, very much so. I mean, international law governs the conduct of wars when they are fought. But you could say that a principal objective of most of us in the profession is to try to find alternative paths to resolving problems other than going to war. And certainly what I do as a judge on the World Court is very much to do that, to figure out how disputes can be settled peacefully.
You must have been to some interesting places as well in your job, having lots of different countries.
Yes, at the State Department,
Yeah.
I certainly did travel around a fair amount. In my current job, the travel
Sure.
that I do when I'm able is actually around the United States to talk about the importance of international law to Americans.
And that's why you're here. Why do you have that as a goal? What is it that you feel people may not know about international law that would be helpful to learn?
Well, what I've noticed in international law, as in many specialized professions, is that people enjoy getting together in conferences and talking to the other experts. But that fairly often we don't put sufficient energy into talking to general audiences about our profession. And so what I've tried to do when the judicial calendar permits is a couple times a year to find a spot in the United States where I can go and have general conversations, and this visit to Idaho and this appearance on your program really fits exactly with what I'm trying to do, because it gives me a chance to talk to regular people about what is my field, international law.
And what is it that you want to emphasize? What is it that you want to let people know about international law and the way that it touches their lives that they may not realize?
Well, first of all, what I try to do is talk about the components of international law that may be invisible but that are out there. And a couple of examples that I could mention are, for example, air services. Sovereignty of countries is the bedrock of international law. So people here tend to think, well, it better be. The United States is a sovereign country, which is true. But that also means that a U.S. airline or a U.S. cargo carrier can't, for example, decide to fly to the Netherlands, where my court is located, without the permission of the Netherlands to land. So how do you deal with this conflict in sovereignties? One way is you conclude a treaty, and the treaty liberalizes that relationship and sets up the conditions under which the carriers of each country can fly back and forth and move people and move cargo. And then once those Americans get to the Netherlands, what happens if they get arrested? Well, if they get arrested, there is a convention, a multilateral convention with many parties on consular relations, and it requires the Netherlands to notify the U.S. Embassy that an American has been arrested. And then a consular officer from the U.S. Embassy can then go and provide assistance to that person. Again, that wouldn't be available if there weren't a treaty that made that a possibility.
And going back to air service, many people may not realize that it's an ambassadorial level position. You know, the United States has an ambassador that deals with these issues, and that man, he's since passed away, but for many years that person was an Idahoan, Ed Stimson, who moved to Montreal and worked on those air transport issues. Kind of a silent issue, but as you say, very important, touches a lot of people. Adoption as well would be one that people might be familiar with, sometimes in a frustrating way, because there are various there's a convention that deals with inter-country adoption to make sure that there isn't trafficking and baby selling.
Yes, you're referring to the Hague Convention. And so for a number of countries, I think about 75, the way that adoption works is under a treaty, the Hague Convention. And the Hague Convention was an initiative of the United States to lubricate the adoption system in ways that protected the interest of the child and the interest of the parents. So again, you have this conflict of sovereignties that underlies it. The child is in a sovereign state, so that state can decide we don't want...
A nation state, meaning like Cambodia or Thailand, or we're talking a country.
Yes, the child is in a foreign country, and that country can decide to shut off all international adoptions if it wants. But with a treaty, the parties to the treaty can agree on what will be sufficient to allow adoption to go forward. So under the Hague Convention, for example, there's a requirement that the adoptive parents get the medical records of the child in advance. And there's also a requirement to make sure that the child is in fact adoptable before the adoption goes forward, to make sure that the child wasn't stolen, for example.
Now, many people are increasingly frustrated with that convention. They say that it keeps their children from getting out in a timely fashion because of the paperwork. So there's sometimes frustration with international law, and even more so, there are some people who really, as I mentioned in my introduction, see it as a threat to our sovereignty. You can drive around this state and see signs that say U.S. out of UN. How do you address people's fears about international law and a global or one world government?
Well, certainly what I mostly try to do is try to shift from the general fear to the specific and try to ask people, what are you actually afraid of? And sometimes I discover in doing that it's misinformation that's underlying the fear. For example, somebody said to me, the Hague Convention, those are UN bureaucrats getting in our way. Well, there isn't a single international bureaucrat involved in implementation of the Hague Convention. Those are simply governments working with each other. And when you're trying to cause an adoption to occur where you have the law of the foreign country, U.S. federal law, and the law of the state where the parents live. That's a lot of law to be applied, and it does certainly take time. So I try to essentially dispel myths and try to react more specifically to what the concerns are.
Some people are afraid of global governance, armies coming in. There's a fear of one world government.
Well, first of all, we certainly don't have a world government now. The United Nations Charter set up the United Nations, but it can't be described as a world government in any way. It looks very, very different from a national government. I can't imagine that our country would ever sign up to any treaty that permitted a hypothetical UN army or foreign armies to just come here. So I guess I'm not afraid of it because international law is voluntary, and I'm not worried that our political leaders will sign on to that kind of a treaty.
Let's get a little bit more into the actual court on which you sit, colloquially known as the World Court. We should say from the very top, this is not the ICC, the International Criminal Court, which gets a lot of press, and is also in The Hague,
right,
but is a much newer court, formed, I believe, in 2002. Talk a little bit about what kind of cases come before you.
Well, we decide cases where the parties are countries. So basically we have country A bringing a case against country B. And we only apply international law. So we don't apply U.S. law or the law of any other foreign country. So that means we're basically applying, in most cases, treaties. And I can give some examples. One of the mainstays of the work of our court has been boundary disputes. When two countries disagree about where the boundary is located, that can give rise to a lot of conflict. When you hear the phrase border skirmish, it means people are being killed in a border area, often because there's a disagreement about exactly where the boundary is. And there are also significant implications for resource development. If there's uncertainty about where a boundary is, not only can there be skirmishes, but also there can be an inability to exploit those resources. And so, for example, the United States and Canada brought a case to our court in the 1980s to settle their disagreements about the allocation of an area in the Northeast called the Gulf of Maine. And we have a case pending right now with two African states who have asked us to settle their boundary.
And a boundary or a dispute over a temple between Thailand and Cambodia. When I first read it, I was like, well, that seems kind of arcane. But as I read more about it, it could actually start a conflagration, a violence.
Yes, in fact, there has been violence in the temple area. Because the difficulty with many of our cases, which I think those of your listeners who are concerned about sovereignty will appreciate, is that small pieces of land can still attract a lot of emotional attention if the view is strongly held in both countries that that is our piece of land.
Now, I mentioned in my introduction the 1984 Nicaragua case in which the U.S. received an adverse ruling from the International Court of Justice and withdrew from what's called the compulsory jurisdiction of the court. It still appears before the court on a case-by-case basis. It's not like we've completely withdrawn. But there was definitely pushback there. There have been other cases where, for instance, there was a ruling on the wall between Israel and the occupied territories in Palestine, and the ruling was adverse to Israel, and it's not following that ruling. Are your decisions enforceable, first of all? I mean, once you've gone through the process of, which can take a long time, of coming up with these decisions, then if countries just kind of thumb their noses, what's the utility of it?
Well, this goes back to the no world government point. So I often say that the UN Charter established a world court, but there's no world president, and there's no world sheriff, and there's no world legislature on most matters. So when we look at the world court, we can't look at it and judge it the way we would judge a national court, because the entire infrastructure of government that exists on the national level doesn't exist for us. Having said that, in almost all cases, our judgments are implemented. They are complied with. And sometimes when they aren't complied with, the reason isn't defiance, it's a difficulty of capacity. Sometimes there's a resource constraint, and that can give rise to delay. And sometimes there are problems in the national system bringing about the compliance. For example, if you have a federal state like ours, and compliance has to occur at the state level, the level of our 50 states, it can be difficult for that national government to bring that country into compliance.
Can you talk a little bit more about the United States' relationship with your court? From what I've read, this decision in the mid-'80s was kind of a turning point in the sense that the U.S. Again withdrew from what's called compulsory jurisdiction, saying, okay, we don't think the court has jurisdiction over us in every matter. And it seems as if there's been some tension between our country and the court. Obviously, you are American, you sit on the court, so we're not totally withdrawn, and we do appear before the court. How would you gauge the current relationship between our country and your court?
Well, I certainly don't perceive of there being a tension between the United States and the court. That is not quite the way that it plays out. I would say that what is more prevalent is an abiding conversation within the United States about the relationship the United States should have with this court and with other institutions. And right after World War II, as you mentioned in your introduction, the balance was in favor of U.S. engaging broadly with international institutions, including the International Court of Justice. I think what we saw in 1984 was an opportunity to reflect on the downsides of that if the United States didn't like the decisions that that court was making. And so that was a particular point where those who were skeptical of U.S. engagement anyway were better positioned to make the case for the U.S. to withdraw to some extent from its engagement with a particular international body. And that conversation has always been part of the conversation within the United States and persists today, both with respect to our court and with respect to other institutions that either exist or that are being created.
Because there is a perception among some that the U.S. is more than willing to judge others in international courts, but not so willing to accept the judgments against it.
Yes, so when I talk in the United States, I basically get questions that have one of two characters. The one is, why doesn't the United States accept more of the ICJ's jurisdiction? Why doesn't the United States consent to be bound in every way and demonstrate our leadership and take the risk that maybe sometimes we would be wrong, we would be judged to be wrong? And the other is, why would the United States ever relinquish any sovereignty to any court? And so I get both of those perspectives, and I very much enjoyed discussing with people both sides of that, and that's actually what I'm doing, is to try to generate conversations around those issues.
But your perception is that the relationship is not a conflictual one at this time?
Yes, I mean, it's not the kind of conversation that really gives rise to that. The United States...
Well, some of these cases are pretty heady. There are countries that don't like our death penalty and don't like their nationals being in our prison system with the death penalty sentence. So they're trying to push against that issue. So there are some tense issues involved.
Oh, certainly. I mean, there is no government that would analyze all of the judgments of the court where I sit and say, we think every single one of those judgments aligns 100% with our vision of international law. There's just no question about that. But it's really very notable, I think, that during the Bush administration, when the United States lost a case in the International Court of Justice, that President Bush said, I disagree with the court's decision in that case, but nonetheless, I consider that the United States is obligated under the UN Charter to implement that judgment, and he then ordered the states of the United States to do so.
Didn't we then subsequently withdraw from the protocol, though, the overarching protocol that deals with death penalty?
No, what happened in that case was that there were Mexican nationals on death row in the United States, and the United States had an obligation to give consular notification, consular notification that I mentioned earlier, to the Mexican embassy, and failed to do so, and that was not in dispute. And so the International Court of Justice said that as a result of that breach of international law, the United States was obligated to give them review and reconsideration of their sentences, and ordered the United States to do that. President Bush said, I don't agree that that convention requires review and consideration. He didn't withdraw from the consular convention. It continues to be a requirement for us to give consular notification, and something that U.S. travelers benefit from when they're abroad. He withdrew from the court's jurisdiction with respect to those cases only.
Yeah, so there still was a little bit of pushback. I wanted to ask you, because the time goes so quickly, and I wanted to ask you a little bit about working with the other judges. First of all, I mentioned in the introduction you were the third female to be elected to the court. There's yet another one since then. I hope there's a day where I don't mention that in introductions, where it's parity, 50-50, as it is in the population. But nevertheless, do you think that as a woman you bring anything different to the court, or are you just doing your, just like any other judge?
Well, it's a group of 15 individuals, and quite often what I'm asked about is about nationality. And so the starting point of many questioners is to assume that the driving characteristic of each judge is nationality. And then sometimes people ask about gender. And really what I've discovered on the court is I'm sure all of those factors contribute to the way we interact with each other, but so do other factors. For example, 5 of us come from the common law tradition that's prevalent in the United States and in the UK, for example. The other 10 come from the civil law tradition. Some of the judges were judges in national courts beforehand, so they bring that expertise. A number of the judges, like me, worked for our governments as foreign ministry lawyers, so we bring that perspective. I have extensive experience as a negotiator of treaties, for example. So when I look at treaty text, I read it the way a negotiator would read it. So it's very difficult to disentangle all of that.
Sure. You are who you are.
Yeah.
And I mean, you're the Chinese judge. One of the women is Chinese. She comes from a communist background, and yet you all are able to come together using international law to set the table, so to speak.
Right. So you could look at our backgrounds and say, oh, they have very different backgrounds. But actually, we were both senior foreign ministry lawyers. We're both about the same age. And she, in fact, studied law at Columbia.
I saw that,
So quite frankly, quite often I find that she and I have much in common.
And people should know that you're not representing the United States on the court, right?
That's right.
You're an independent judge. You happen to be American.
That's right. The judges are independent of their countries of nationality. I often say that when I worked at the State Department, I served my government by representing it, and now I serve it by being independent of it.
And you have said that one of your objectives is not necessarily people shouldn't be necessarily there to win, but the objective is to settle a case. Because sometimes in the winning of a case, there can be retribution, recrimination, increasing animosity. So it's not about winning and losing, right, as much as it is coming to a settlement or a compromise of some sorts?
Well, I think the answer to that really depends on the particular dispute. And the different disputants might have different reactions. So say, for example, from the perspective of the United States, there might be 2 countries that are fiercely arguing over where a boundary should be. We might not have any particular interest in where that boundary is, but we might have a considerable interest in them settling where that boundary is. They might care a lot about where it is.
I see.
So I think it depends a little bit on the perspective that one brings. But often governments are quite interested in actually getting a resolution. But sometimes, no, they really want their resolution.
As I read about some of these cases, and they can go on for years, as I'm sure your work in the State Department did on treaties and other disagreements, it must take incredible patience to do what you do, because you're in it for the long haul. These are not decisions that, you know, if you go to court downtown, the decisions are going to be coming much more rapidly.
Yes, it is. It is very much a slow process, and I am actually not a very patient person, so it can be a challenge. Sometimes the pacing is valuable because the opportunity to cool off is helpful, but sometimes the party that initiates a case can be quite frustrated with the pace.
As we continue to wrap up, looking out onto the horizon, I'm trying to think about some of the cases as our world changes that might come before the court. And I'm wondering if we might start to see climate change issues. You know, I know you're interested in the environment, and there are already ocean cases regarding the oceans that come. Do you think we're going to see that out? Disagreements over pollution caused by different countries?
I wouldn't want to speculate about future cases, but I could mention a couple cases that we have on our docket that are on the horizon. We have a case this summer that we'll hear that Australia brought against Japan. Japan engages in whaling operations off of Antarctica, and Japan takes the position that those activities are lawful as whaling for scientific purposes, and Australia takes the position that the whaling is in violation of a treaty, the International Whaling Convention. And we have another case that's environment related. Ecuador has brought a case against Colombia, and Ecuador claims that Colombia's aerial spraying as part of its anti-coca program has caused harm in Ecuador.
Interesting. I think we probably will see some more environmental cases. It'd be interesting if we start seeing outer space cases too, as people start claiming that area. I want to cycle back to the issue of being a woman in a prominent position. You worked for Hillary Clinton directly when she was Secretary of State. And when you look out in the landscape, you know, many other countries have had female leaders. Do you think we're approaching that point finally where the U.S. and maybe in the form of Hillary Clinton will join those countries in having a female leader? I assume you feel she's quite qualified to do that.
Well, I certainly enjoyed working with Secretary Clinton. I considered it a real privilege. Of course, from my position, what I see is the United States looking rather good in terms of gender issues as compared to many parts of the world. I was the first American woman to be put on my court, but if you look around my court, there are plenty of other countries that still have the opportunity, shall we say, to name a woman to our court. Well,
nice workaround on that. I am appreciative that you took the time to speak with us about what you do, and look forward to learning more about international law. Thank you very much for taking the time to be here.
Well, thank you. I've really enjoyed it.
You've been listening to Judge Joan Donoghue. She sits on the World Court. I'm Marcia Franklin. Thanks for tuning in to this edition of Dialogue.
Presentation of Dialogue on Idaho Public Television is made possible through the generous support of the Laura Moore Cunningham Foundation, committed to fulfilling the Moore family's legacy of building the great state of Idaho.